Judgment in the appeals Smith, Ellis, Allbutt and others against the Ministry of Defence.
Lord Hope will give the judgment.
These proceedings raise fundamental issues about the duties of care owed by the executive to servicemen engaged in active operations overseas. They concern three sets of claims which arise out of the deaths of 3 British servicemen and the serious injuries of 2 others while serving in Iraq. The first set, known as the Challenger claims, arise from a friendly fire incident involving British Challenger tanks, which caused the death of Corporal Stephen Allbutt and the serious injury of troopers Daniel Twiddy and Andrew Julian. They are brought in negligence and allege failures by the Ministry of Defence to properly equip the tanks involved and to give the soldiers adequate recognition training. The second set, known as the Snatch Land Rover claims, arise from the deaths of Private Philip Hewitt, son of the claimant Susan Smith, and Private Lee Ellis, father of the claimant Courtney Ellis and brother of the claimant Carla Ellis, by the detonation of improvised explosive devices, known as IEDs, close to the Snatch Land Rovers in which the soldiers were travelling. The claimants all claim that the MOD breached the implied positive obligation in Article 2 of the European Convention on Human Rights to take preventive measures to protect life in the light of the real and immediate risk to life of soldiers who were required to patrol in Snatch Land Rovers. The third, the Ellis negligence claim, is brought by Courtney Ellis alone in negligence. It is based on various alleged failures at common law on the part of the MOD. The MOD argued that the Snatch Land Rover claims under Article 2 of the Convention should be struck out because, at the time of their deaths, Private Hewitt and Private Ellis were not within the jurisdiction of the United Kingdom for the purposes of the Convention, and because, on the facts as pleaded by the MOD, the MOD did not owe a duty to them at the time of their deaths under Article 2. It was also argued that the Challenger claims and the Ellis negligence claims should all be struck out, first on the principle of combat immunity, which operates to exclude liability for negligence in respect of the acts or omissions of those engaged in active operations against the enemy, and secondly, because it would not be fair, just, or reasonable to impose a duty of care on the MOD in the circumstances of these cases. The High Court and the Court of Appeal considered these arguments. The effect of the Court of Appeal's judgment was, first, that the Snatch Land Rover claims under Article 2 of the Convention should be struck out because the deceased were outside the jurisdiction for the purposes of the Convention, and secondly, that the Challenger claims and the Ellis negligent claim at common law should proceed to trial. The following issues were before the Supreme Court, therefore. First, in relation to the Snatch Land Rover claims, the very important issue as to whether, at the time of their deaths, Private Hewitt and Private Ellis were within the jurisdiction of the United Kingdom for the purposes of the Convention, and secondly, if they were, whether, and if so to what extent, Article 2 imposes positive obligations on the United Kingdom with a view to preventing the deaths of its own soldiers in active operations against the enemy. In relation to Challenger claims and the Ellis negligent claims, the question is whether the allegations of negligence should be struck out because they fall within the scope of combat immunity, or because it would not be fair, just, or reasonable to impose a duty on the MOD to take care to protect against death or injury in the circumstances. The Supreme Court holds unanimously that in relation to the Snatch Land Rover claims, Private Hewitt and Private Ellis were within the United Kingdom's jurisdiction for the purposes of the Convention at the time of their deaths. By a majority of 4-3, the Court holds that the Snatch Land Rover claims should not be struck out on the ground that the claims are not within the scope of Article 2 of the Convention, and that the Challenger claims and the Ellis negligent claim should not be struck out either on the ground of combat annuity or on the ground that it would not be fair, just, or reasonable to extend the MOD's duty of care to those cases. The effect of the Court's decision is that all three sets of claims may proceed to trial. some explanation is needed. As far as the Convention jurisdiction, the first point is that in its judgment in July 2011, in the Al-Skani case, the European Court of Human Rights decided that 6 Iraqi civilians who had died as a result of the actions of British armed forces in Iraq were within the United Kingdom's jurisdiction for the purposes of the Convention. That judgment does not answer the issue that arises in this case directly, but elements can be extracted from it which point clearly to the conclusion that the court reaches in this case. It formulates a relatively general principle that extraterritorial jurisdiction can exist where a state, through its agents, exercises authority and control over an individual. It also indicates that the Convention rights can be divided and tailored to the particular circumstances of the extraterritorial act in question, as opposed to being an indivisible package. A state's extraterritorial jurisdiction over local inhabitants exists because of the authority and control that is exercised over them as a result of the authority and control that the state has over its armed forces. The armed forces themselves are brought within the state's jurisdiction by the application of the same general principle. As far as the claims, the Snatch Land Rover claims are Article 2 of the Convention are concerned, the explanation is this. In this area, the court must fully recognize the wide margin of appreciation to be given to the state and avoid imposing obligations which are unrealistic or disproportionate. But it must give effect to those obligations where it would be reasonable to expect the individual soldier to be protected by Article 2. Policy decisions made at a high level of command and things done on the battlefield itself will fall outside the scope of Article 2, but whether claims which are between these two categories are within the scope of Article 2 will require the exercise of judgment in the light of the facts of each case. The present claims provide only a brief outline of the claimant's cases, and they predate developments in relevant case law on Article 2. The circumstances in which the various decisions were made need to be inquired into before it can be determined with complete confidence whether or not there was a breach of Article 2. It must be stressed, however, that given the court's guidance on the margin of appreciation to be given to the state, it is far from clear that the claimants will be able to demonstrate such a breach. As for the challenger claims and the Ellis negligence claim, the explanation is as follows. The doctrine of combat immunity should be construed narrowly and should not be extended beyond its established scope to the planning of and preparation for active operations against the enemy. The challenger claims are not within the scope of the doctrine because they relate to decisions about training and equipment which were sufficiently far removed from the pressures and risks of active operations against the enemy. The Ellis negligence claim is less obviously directed to things done away from the theatre of battle, so it is arguably within the doctrine, but it would be premature for these claims to be struck out on this ground, and the issue whether they are within the doctrine should be open to further argument in the light of the evidence. As for the claims at common law, considerations similar to those affecting the Snatch Land Rover claims under Article 2 arise in relation to whether it would be fair, just, and reasonable to impose a duty of care on the MOD in this area. Differing from the majority view is that the circumstances in which active operations are undertaken by the United Kingdom's armed services today vary greatly and cannot all be grouped under a single umbrella as if they were all open to the same risk of judicializing warfare. So the court holds that the question whether the negligent claims in this case entail subjecting the MOD to duties that were unreasonable or excessively burdensome cannot properly be determined without hearing the evidence.
The court is now adjourned.